Namaskar, ladies and gentlemen. I'm Vimal Vaklu, former Chairman, Managing Director of TCIL and Board Director of Public Police NGO. I welcome you all to today's event. We at Public Police NGO have been holding webinar series on topics of immediate concern to the general public for quite some time. In the past, we have had webinars on the topics like how safe and secure are our bank deposits in the banks. Is it feasible to have CCTV systems in the police stations? Effective implementation of human rights in India, role of telemedicine in mitigating the current health challenges. This was during the COVID time. Are the under trials in India getting true justice? Handling the challenges posed by misleading advertisements. We had a number of series on that. Misleading price tags, discounts on medicines and generic medicines, a dream project of the Prime Minister. Uniform Civil Code, reinstating women's empowerment through strong values, navigating the golden years, senior citizens, social security challenges, solutions, part 1, 2, and 3, 3 parts, and reinstating women's, that UCC, I already mentioned that. All these webinars have been uploaded on our Public Police NGO channel on the YouTube. Today, the subject of our discussion in this series is from Indian Penal Code to Bharat Nyaya Samhita, evaluating the revamp of Indian criminal justice system. From bringing terrorism and organized crime under the ambit of ordinary criminal law, introducing gender neutrality for offenses pertaining to children, to repealing sections 377 that criminalized homosexuality, the Bharati Nyaya Samhita bill makes key departures from the Indian Penal Code, which has been replaced. Now, new offenses have been added, which include false promise to marry, mob lynching, organized crime, terrorism, attempt to suicide. And some of the offenses have been deleted, as mentioned: unnatural sexual offenses, adultery, thuggery, and other inclusions are fake news, sedition, where Rajdroh is replaced by Deshdroh, and mandatory minimum sentence. And what's interesting is that, there are a lot of changes, but this is all from the public domain, whatever information we have. But today, in order to get enlightened on the subject in detail, we are privileged to have, our panelists, Dr. Vikram Singh, former Director General Police, Uttar Pradesh, and Chancellor of Noida International University, and a well-known face on the media. Shri P.K. Malhotra, former Law Secretary, Government of India, Board Member of Public Police NGO. To make the webinar more interactive, I'd request all the participants to pose their questions in the chat box so that they find their answers during the course of this webinar. So I shall request both the panelists for their opening remarks. We'll start with Dr. Vikram Singh. Yes, sir.
Good evening, Mr. Vaklu. Good evening, gentlemen. It's a great honor to be a part of this wonderful and vibrant interaction. And I had on various platforms mentioned that these changes are not ordinary or cosmetic changes. These changes have come about after a lot of forethought, indeed brainstorming, and at multiple levels, at multiple channels, to incorporate almost all the recommendations made by the Honorable Supreme Court, the directions given by the Honorable Supreme Court, the Law Commission, and the requirement of the society. In your own opening remarks, Mr. Vaklu, you had mentioned that what the society wants today, the new era crime, because what worked yesterday will not work today. 1860 to 2024 is a long period of time. Decades and decades have passed. And to incorporate all that, and I would say that you will see for yourself that of the 511 sections of the Indian Penal Code, there are now just about 356 sections in the Bharatiya Nyaya Samhita. There have been changes in 175 sections. New 8 sections have been added and 22 sections have been removed. Under these circumstances, you will see that, yes, the Honorable Committee had applied their mind and had taken the words of wisdom from MPs, chief ministers, the governors from 18 states, 6 UTs, 16 high courts, 5 law academies, 22 universities, 142 members of parliament, 270 MLAs and MLCs, and many members of the public. I too had the distinction of making my presentation because I was summoned by this honorable and august committee to make a presentation in the Rajya Sabha, and in a slot that was scheduled and slated for 40 minutes, I was allotted 3 hours. And I made my presentation very well received. And I must compliment the committee for coming out with a wonderful draft. During the course of our deliberations today, you will see what revolutionary contributions have been made to address the fast-growing crime, the crime that is organized, anti-national elements, and those that were sticky issues, both in the media and society, have also been addressed wonderfully. Thank you, sir.
Hello.
Malhotra Sahab, your opening remarks. I'm sorry, I was on mute. Yeah, please.
Yes. No problem. Thank you, Mr. Vaklu, for the excellent opening remarks made by him. And I know his contribution in the process has been a very excellent contribution which he has made in his views which he has given before the committee, and most of his views expressed have been duly considered by the committee and wherever necessary have been incorporated. As Dr. Vikram Singh has said, changing the law was not an easy task. A law which was made in 1860, and I think the law which has bare minimum amendments in the last 160 years, replacing it with a new law was not an easy task. But this government took the initiative and they have done it not only with regard to IPC, which is the major criminal legislation, in addition to other legislations which have been passed by the government, by the parliament from time to time, the special legislation which have been passed by the parliament. It was necessary that the changed. But I would like to add a word of caution. Changing the law itself, what doesn't mean that you are changing all the offenses which were there in the IPC. Most of the offenses as it is have been retained. Whatever was not required has been done away with, and certain new offenses have been created which have become a necessity with the passage of time. And IPC is not the only law, but the procedural law under which the cases are tried. Under the IPC, that is the CRPC, has also been changed. Of course, the original CRPC was of 1898, which was replaced by a new legislation in 1973. And now we have got a new law. And in addition to that, most importantly, the Evidence Act, which I think was equally important and which was creating a lot of hurdle in expeditious trial of cases, have also been changed. So all these 3 legislations which have been passed by the parliament, I think they are a game changer for the criminal justice administration system in the country. Maybe we have not achieved the perfection because as I normally say, perfection is a marriage, but we have moved in that direction and some very important changes have been made in the law. As Mr. Vaklu, you also mentioned in your opening remarks, and Dr. Vikram Singh also mentioned, let me share with the participants of this webinar that there are 20 new offenses which have been added, 19 provisions have been deleted, In 33 offenses, punishment of imprisonment has been increased, keeping in view the gravity of the offense. In 83 offenses, punishment of fine has been enhanced. And in 23 offenses, mandatory minimum punishment has been introduced. Another important concept which has been introduced, because we are talking of reforms in the criminal justice system, and the reform as a first step which has been introduced and which I welcome is that the concept of community service has been introduced for some minor offenses committed. And I think this is just a beginning, because we don't want to overburden our jails with the under trials as well as with the convict. And in that process, I think a very good step has been taken in the new law, where the concept of community service has been introduced. Of course, I will come to it a little later. And some of the new offenses which have been introduced, as Mr. Vaklu yourself has also introduced, the organized crime, the terrorist act, the petty organized crime, hit and run cases, mob lynching, hiring child to commit offenses, sexual exploitation of women by deceitful means, snatching, abetment outside India, and acts endangering the sovereignty, integrity, and unity of India, and publication of false and fake news are some of the new offenses which have been introduced under the new IPC, which will come into force from 1st July 2024. The date has already been notified. New law will come into force. There may be certain issues. Whenever you introduce a new law, replacing a law which has been in existence for more than 160 years, there are going to be some operational difficulties. But I think that that's only a question of time. With the passage of time, once the law start implementing, the things will change and people will start understanding the new provisions, and probably courts and the legal fraternity will interpret all these legislation in the way the legislation wanted it, to get the criminal justice system more effective to render justice for the common man. With these opening remarks, I hand over the mic to you again. Thank you very much. I'll further supplement it as the discussion goes on.
Thank you, Malhotra Sahab. Now, coming back to Dr. Vikram Singh. Well, sir, in your opinion, which is the most, a game changer in all these changes that have been made, and why?
First of all, may I submit with the greatest of respect that the critics have been able, for whatever reasons, keep criticism that it is a knee-jerk reaction that has prompted the government to come out with these new legislations. Certainly not. In the year 2019, it was for the first time that the Prime Minister hinted that there will be a change in the old feudal laws. And in the same year, in December, in the DGP's conference, 8 December to be precise, the Home Minister said that we must now work in and pool our resources and apply our minds to get the legislation and get the wish list from all the grassroots workers and members of the public, the stakeholders, especially the women folk, the weaker sections in society. So you would understand that bicycle theft was a major crime, burglary, house trespass was a crime. Nobody heard of what organized crime was. Till the time kidnapping for ransom, contract killing, capturing, rigging the elections, human trafficking, as also extortion, and you name it. Indeed, such crimes were emerged in the late 80s and early 90s. Then you had anti-national activities, terrorism. So as Mr. P.K. Malhotra had mentioned, that Section 150 incorporates and organized crime and terror have been defined very, very clearly. Mob lynching was a bone of contention. Mob lynching was one, there is no offense defined as mob lynching. Today, mob lynching has also been defined in the statutes. And the punishment for mob lynching ends up at 20 years and capital punishment too. So the harshest of possible punishment has also been earmarked for mob lynching. So people who were saying, in fact, the very people who were saying that there is no provision will come. And if it will come, it will only have cosmetic changes. When it comes to snatching, chain snatching, snatching of mobile phones, snatching of other valuables and jewels from the women folk, that too is something that has happened in the recent last 3 decades. It did happen earlier, but it has assumed epidemic proportions only now. So the three things. Then adultery, the Supreme Court had struck it down, and the section 437, 497 was set aside by the Supreme Court in the year 2018. That also has been set aside and it does not figure in. Now, rape carries a punishment of 20 years. You must have heard what Mr. P.K. Malhotra said in legal terms. I will say you must have heard of love jihad, sexual intercourse by false promises, deceptions, and there was a criticism also that this is there to denigrate and perhaps question interfaith marriages. It is not the case. It is there to identify that if there is a marriage out of deceit, out of false promises, deception, then there will be consequences. The point to note here is that it is religion neutral. It does not say that a person belonging to X faith would be liable and a person belonging to Y faith will not be liable. Any person of any faith who is involved in this kind of offense will have consequences in similar parameters and in similar denomination. So this criticism also does not hold good. And on a lighter vein, I also read through what are the criticisms that are there for the Bharat Nyaya Samhita. I came across to CNN News 18 said that the construction of the legal sections is clumsy and the grammar is poor. Well, I find this criticism itself to be quite pedestrian in itself. And the second criticism is that all nomenclature should be in English and it should not be Hindi. Well, that is debatable. Apart from these two criticisms, I'm not there. Now, the third thing which I would like to say, that public servants who make false statements in a court of law or submit false documents, there's a punishment of 7 years in that. And the biggest sumptuous takeaway is that the best practices of the two laws in the country, Maharashtra Organized Crime Control Act, that is the MCOCA, and the Gujarat Organized Crime Control Act, GUJCOCA, the essential ingredients of these two acts have also been incorporated in the Bharatiya Nyaya Samhita. That of the matter is that already the ready reckoners are already available to us. That will indicate what is section 420, what is 380, what is 302, and all are available in any ready reckoner, and any number of books and guides are available to take us through. Therefore, I would say that this is a wonderful measure, a proactive measure that has been able to identify the new era crime and also how to deal with them very effectively with an element of finality. Thank you, sir.
Thank you, sir. Thank you very much for that comprehensive overview. And of course, I also feel that there have been some concerns in the society over false promises of marriage and all that, and and also mob lynching, etc. So it's good that those issues have been addressed. Now, Malhotra Sahab, you mentioned about this decongesting of jails by virtue of this community service. Could you elaborate a bit more on this?
Mr. Waklu, before I come to a question which you are posing to me, which of course is very important, and Dr. Vikram Singh also said, this is loosely worded term, be reformative, and what kind of reformative action will be taken. I think this has been left to the discretion of the court. But I don't find anything wrong in that. Once you are starting a new system, you have to learn from the precedents which are available in other jurisdictions, the kind of reform which are suitable to our society, the reforms which you want to bring in our own society. And I'm reminded, I think all of us remember, there was a movie, I'm forgetting its name, where Rajesh Khanna, I mean, unfortunately, he was a truck driver and committed a crime where somebody came under the truck and he died, and he was tried for murder. But the judge asked him to go and serve the family whose bread earner has died under in the accident which was committed by him as a truck driver. So that kind of reformative approach, it's
Yes.
not that it's not known to our people. This kind of reformative approach has been shown in our movies decades back. So this is only
Decades back.
one form which I'm talking about. It's not that there are not other reform activity, but if you're talking me about the major changes which have been brought in the new legislation which need, one of course is reformative, another is giving a separate chapter or thrust to the crime committed against the state. That is the act endangering the sovereignty, integrity and unity of India, and the crime against women and child. I think a new chapter on this particular offenses has been added, and I think this will definitely bring lot of reform in the trial stage also, because in the Evidence Act also certain timelines have been prescribed within which the trial must take place and final decision must be taken by the courts. In the reformative approach, again coming back, and as Dr. Vikram Singh also said, yes, we need certain clarity, but that clarity need not necessarily be put in the legislation. That clarity can come through the judicial pronouncement, because the judges who are deciding these cases, they are the best judge to judge the situation under which a crime has been committed. In case a person is a habitual offender and he commits the same crime of kind of crime again and again, obviously, probably reformative approach for him may not be as effective. Like as on today, also we have an act which is known as Probation of Offender Act. The person who has committed one crime and otherwise his track record is good, he is left on, he is set free on probation and he is kept under surveillance of the court. I think that is another example which I thought I can share. So probably that kind of clarity immediately was not needed, but this will come through the judicial pronouncement as well as through the mechanism which has already been adopted by our courts. The Supreme Court, whatever laws have been struck down by the court earlier or what taken care of in the legislation, Dr. Vikram Singh also mentioned about it, and I think that's a very good step. And I also find that the references which were made to the Queen or the colonial era, like the British India or justice of peace, the words which have become irrelevant for our day-to-day use in our criminal justice administration system in our country, they have been done away with. And that is why when Dr. Vikram Singh mentioned about the language used, whether it should be Hindi or the words should be used in Hindi, we should not forget that our official language is Hindi under the Constitution. So if you are promoting more and more use of the words which are used in Hindi, nothing wrong in that. We are promoting only the constitutional principle which is mandated, and the government is also supposed to discharge this function as for the official language of the country. And I think time has come when even the Supreme Court is also promoting it, not only the official language which is Hindi, but also the regional languages which have been recognized by our constitution. Only point which I would like to highlight here is, and probably again in addition to like in the reformative approach, what I find is that some of the offenses which have been defined in the Act overlap with some of the offenses which are defined under the special laws. And there is a little bit of confusion in that, because the punishment prescribed as well as the procedure prescribed for trial, either under the IPC or for the similar kind of offense under the special law, is little bit different. Just to give one example, I would like to highlight here the cases under the for adulteration of food or drinks. And what I noticed is that IPC section 272 and 273 dealt with it and prescribed imprisonment up to 6 months or fine with 5,000. But clause 274 and 275 is the new clause under the Bharat Nyaya Samhita, which deal with the same subject. But if you look at the Food Safety and Security Act of 2006, it provides imprisonment up to life and a fine up to 10 lakh for manufacturing, storage, sale of unsafe goods. This is what the provision is. So I think if there is a difference in the special legislation and the general legislation, obviously we know the special legislation will prevail, provision of special legislation will prevail. This is what the general law is. But the fact remains, its implementation sometimes becomes a problem, and the counsel on both sides probably try to misguide the courts also as to which provision of law should be applied. Suppose the investigating agency has forgotten to charge them under the special law and prosecute them only under the general law. Probably the difficulty may arise. Probably, I think these are the things which will be sorted out with the passage of time. And as I earlier said, from the law, it is only by way of interpretation. When it comes, when the situation comes, our courts are wise enough to take a stand and to interpret a law in accordance with the justice delivery system. Thank you.
Thank you, Malhotra Sahab. Just a request. If you could find a better place in the sense there is some weak signal which is causing disturbance like that in your phone, probably if you could correct that, it'll be really great. Thank you.
Let me see if I can change the position. Yeah.
Now, coming back to Dr. Vikram Singh, well, sir, with this new provision making the special act for this terrorism, how much do you think the Bharat Nyaya Samhita will be able to take care of the challenge which we have been facing for quite some time?
In a most critical and revolutionary manner. Please understand that till now, we had just preventive detention, something like POTA, something like UAPA. Terrorism has been defined for the first time, and all the evidence, like you have the best ingredients of the MACOCA, Maharashtra Organized Crime Control Act, GUJCOCA, Gujarat Organized Crime Control Act, and all those have been incorporated, the complicity of public servants, and what is relevant and what is irrelevant, what will constitute a terror act, as also the wanton destruction, the use of automatic firearms. Everything has been quantified so that there's nothing left to the imagination, because the general allegation, and who would understand better than our organization, that innocent boys are rounded up. I think we've heard that ad nauseum. Innocent boys are rounded up, and after the trial of 5 or 6 years, they are acquitted. They are not acquitted. They are given the benefit of doubt. So there's a world of difference between acquittal, honorable acquittal, and a benefit of doubt. So now the quantification and what is material and the ingredients of terror, they're absolutely foolproof and fail-proof. It is not to the imagination of the investigating officer or the prosecutor or both. They have to quantify, and like a mathematical algorithm, to trace, identify, pinpoint, collect the evidence, and produce it before a court of law, like an absolute mathematical formula, so that the ingredients are complete and they disclose the commission of an act of terror. Therefore, the investigation becomes simple, the decision making becomes simple, and the collection of evidence also, what is relevant and what is irrelevant. So all the media hype, because you would understand that there is a barrage of fake news and deep fake news and propaganda material that tends to overcast honest and an investigation with utmost integrity. But this, I think, has also been undone by incorporating not only the best practices, but also what is relevant and what is irrelevant, the GUJCOCA and the MACOCA. I think it is a win-win situation for the investigators, the prosecutors, the court of law, and hence for the whole country, that we would have addressed this major sticky issue in one go by making these very important and critical changes.
Thank you, sir. Thank you very much. I mean, that gives us a lot of hope that there'll be a check on terrorism with this new law. Well, coming back to Malhotra Sahab, in your opening remarks, you mentioned that the other evidence, like maybe electronic evidence, also is going to be acceptable now. Do you think it'll have some implication of the change in implications on some of the cases which were closed, high-profile cases which were closed earlier simply because they found that this electronic evidence is not sustainable in the court of law?
Yeah, I think that's a very important point, Mr. Waklu, which you are raising, because now under the new legislation, the electronic and digital records are included in the definition of documents. And that definitely is going to be a game changer, because in this world of technology where everything is done through technological means and the technology is being used even for committing crime, if the documents and the digital records, electronic document digital records are not allowed to be used in trial, I think it creates a hindrance. And as Dr. Vikram Singh said about the journal statement, that many a time the accused are acquitted by giving benefit of doubt and not on merits. I think with this kind of recognition of evidence, probably the prosecution agencies will be in a much better position to present the cases before the trial court, and probably the conviction report, the conviction rate will also be much better. In addition to this, the other point which I would like to make, of course, I think this has not yet come for discussion. Of course, Dr. Vikram Singh said it, that a lot of thought process has been gone into, and the government itself has said that they are going to bring this kind of changes. Committee was constituted. After the committee was constituted, a bill was drafted. The bill was drafted, bill was introduced in the parliament. This went to the standing committee. Among the standing committee also, there was discussion on the basis of recommendation by the standing committee. The earlier bill which was introduced in the session, in the budget session, was withdrawn, and in the monsoon session, another bill was introduced. So if I'm talking about the procedural aspects, people have been expressing concern that in spite of all this due process which has been followed, probably when the new second bill was introduced, there was a need that probably there should have been a proper debate in the parliament. The parliament passed these three important legislation in a very short duration, and the kind of debate which was expected to take place in the parliament has not taken place. Maybe if the validity of any of the provision of this legislation is challenged in the court of law, probably the courts will was introduced in the bill. Well, as I said, thought process has gone into, consultation has taken place, pre-consultation process which was needed with regard to the provision of the bill has gone into, but the provision of the bill which was passed by the parliament have not come in the public domain for pre-consultation, which is required. So probably that is one negative aspect on which sometimes the bill is criticized. But I am also of the view, how long you can go on consulting the public if you have already consulted prior to the introduction of bill? After introduction of the first bill by the parliamentary standing committee, then probably government was well within its rights to introduce the second bill. And because a lot of consultation has already taken place, so consultation also has to stop one day. But had it been given, because when this bill was passed, I think 146 MPs were under suspension. They were not participating in the debate. So I think that is one concern which some of the people are expressing, and there is a need, probably if this consultation would have taken place on the floor of the House, maybe some of the points which we are discussing today could also have been taken care of, and by way of an official amendment, certain more reforms could have been brought. But it's not that the opportunity is lost. Such reforms can be brought even in the by introducing further amendment in this particular legislation after we see its implementation from 1st July onward, and as and when views are coming from the courts, because some of the changes which have been brought even today also under the law are based on the judgments given by the Supreme Court from time to time, striking down certain obsolete provision of the IPC.
Thank you, sir.
Thank you
very much. That was an important point. And now coming back to Dr. Vikram Singh, for quite some time, public property was treated like nobody's property. And there used to be a lot of challenges. The moment somebody would incite mobs and they would start destroying property. Now there is a graded punishment, as they call it. And this, of course, has already been started by some of the state governments, on, under a different pretext. But how much do you think this will be effective in preventing damage to public properties like that we have been having in the past?
Mr. Waklu, I must compliment you for this wonderful question. And the question and its various ramifications. The first, the necessity. We have seen the grotesque and the ugly destruction of public and private property, wanton destruction, as if it belonged to enemy. The ground reality is that in any agitation, the first target is public property and private property, vandalization of property, and then attack on women folk and children. Now, this aspect has been addressed by many state governments, especially if I talk of Uttar Pradesh, it has been structured, and also it has been structured in a manner that those who have indulged in arson, rioting, and also destruction of public property, they were named and shamed. That part we will not discuss just now because it is not a part of this statute. But the fact that in the case of when the PFI was banned, may I take you back when the PFI was banned, there was destruction and large-scale looting and arson in Kerala. The Kerala High Court had to intervene that those who had vandalized public property will have to pay to the Kerala Transport Authority as also to the Kerala government. With this intervention, I think that set the ball rolling, that many other states also enacted their own laws. But this Bharat Nyaya Samhita has also structured it in a manner that there will be consequences. Now to the other part, which is even more sensitive to what you have said, what impact it will have. The taste of the pudding lies in its eating. A faithful implementation of an act also is $1 million question. There are governments that will implement it lock, stock, and barrel and give a befitting message and a befitting punishment to all those who have quoted the recipe of disaster. But there are those who would be reluctant, number one, to file an FIR. Then there are those, if FIR is filed, they said that these are perhaps misguided youth and their career should not be ruined. You would understand misplaced compassion towards rioters and arsonists for political expediency. Then these laws, you have a weapon in hand, you have a technology in hand, you have a law in hand. Faithful and impartial implementation will solve so many problems. But the $1 million question is, will the faithful and impartial implementation happen? I think in a scale of 1 to 10, I would say 50% probability is that it will be. And 50% probability is that in a setup where there is a pursuit for political victory, political advantage, political expediency, there you know the answer would be to look the other way and not to register cases.
Thank you, sir. Thank you very much. That's a big relief, I would say, for the country. I mean, I would move forward. Well, Malhotra Saab, coming back to you, I mean, there has been a clause for gender neutrality when it comes to some of the laws pertaining to particularly children. What's your take on that? This is a new change.
Mr. Waklu, this is another important question which you are raising. As we during the course of discussion has pointed out, that there are issues which need to be addressed, and there are certain reforms which need to be looked into in due course. And we have mentioned that then when you are talking about the community service, the concept itself is unclear and need to be clearly established, or which will be established in due course, which overlap with special laws. I mentioned about that also, which need to be corrected, or probably we will see how it goes on. And connected to that is the issue which you are raising, that is with regard to the gender neutrality in respect of some of the offenses. And I think that's a very important aspect. In some cases, it has been done, but in some of the cases, it still needs to be done, which has not been taken care of. Take, for example, when Nirbhaya case happened in 2012, the Criminal Law Amendment Bill was introduced. There were many new offenses like voyeurism and other offenses were added. And based on the recommendation of stalking and voyeurism were added, based on the recommendation of Justice Verma committee reported, the law was amended. and certain other additional provision for expeditious disposal of this kind of cases was also made. But the offense was not, offense of rape was not made gender neutral at that time. I think this was a good opportunity for the government that once they are making the law, they are bringing a new law, probably offense like rape could also have been made gender neutral, because there are so many changes which have been taking there are so many changes which have been taking place in the society. And I think this kind of offenses are not in our society, are not one-sided only. It can be the other way around also. So probably this making the offenses gender neutral probably is also equally important. Another aspect which I want to highlight here, because we are pointing about certain improvements which can still be brought in spite of in spite of the fact that all improvements which have been brought, there are still certain areas which need to be looked into. And one is, of course, we have done away with the offense of sedition under section 124A of the IPC, which has been deleted. But we have added offenses against sovereignty. But if you look at the definition which have been provided, probably all the elements of sedition are already incorporated in the offenses against the state, or rather the scope of that has been enlarged. My only concern is that the state authorities or the implementing agencies will keep a check on themselves and they will not misuse this kind of offenses. Dr. Vikram Singh also mentioned about it, that 50% of the people, yes, they want the law to be enforced in the right direction, but 50% of the people, maybe for whatever reason, they look the other way around and don't implement the law the way it is required to be implemented. But I have full faith in the judiciary, as I said earlier, that probably when it comes to the implementation, they will take care of all these kind of things. And whatever concerns are being expressed by the general public or by the people who knows this subject, probably they will be taken care of when the judicial pronouncements are given or when the trial takes place in the court.
Thank you, sir. Thank you very much for that interjection. Actually, today we also have Justice Satish Chandra with us. He has joined us. We could have your view also, sir.
Thank you very much. Both the speakers, Dr. Vikram Singh and P.K. Malhotra, have already given the inside story of the new 3 acts. And I have seen also these 3 acts which is going on. In fact, it appears that the old 22 sections were repealed, which includes the attempt of the suicide and unnatural sex and sedition, 124A, all these things. But there were some points, as Mr. Malhotra said, Vikram Singh said, that needs to define. For example, the community service. A committee will be formed, or what will be the modus operandi, I don't know. Suppose tomorrow a magistrate is saying to the accused, you clean the shoes of everyone who is coming to the court, including advocates. Is it not a violating Article 21? Because dignity is already involved. So such type of things will come in by the way of the judicial pronouncement in due course, and they will define in due course community services. And also, you will see Mr. Malhotra has said that there are duplications of some sections which have already a provision of the special acts. For example, if a crime is committed by a child, then naturally trial will be there in the Juvenile Justice Care and Protection Act 2015, not in general code, because a child is minor, or you can say the accused is minor, so that will go there. And 300 CRPC is also mentioned about this. There will be the trial by the juvenile code, not by this ordinary court. So there was no need for this purpose. And secondly, if you will see the terrorist activities, we have the special act, Unlawful Activities Prevention Act 1967, section 145 to 156. We have defined what is the terrorism, what are the form of the terrorism, already have defined. So I think this is the duplications. And for example, elections, 167, 175 sections, there are there. So Representation of the People Act 1951 will take care already. So these duplicate sections can be seen whether this will work or not, and And of course, the court will decide. Otherwise, this act appears nicely and to meet the challenges of the time. And court justice will say that punishment will be little harsh in comparison to the IPC. For example, if you see one snack in your room, what you will do? Naturally, will throw it away or will try to kill it. But how many persons can be killed by the snake? Only one at a time. But these drug mafias, how many persons they are killing? In IPC, this was the 6 months punishment. Why not 10 years? Why not the life imprisonment? Why not hang? Because they are killing so many persons. Spurious insulin is there, spurious medicines are there. So this deterrent punishment is required for that purpose. And I think it is in due course it will be there. Another aspect was left out. That was you have taken under 306 the extortion, but not the blackmailing. Blackmailing is also required, who severely force the person to give money or do something by threatening or make a knowing something which he or she wants to keep secret. So blackmailing is also there. So this should be made an offense and might have been covered it. Somehow, let us see what will be there. So with these points, I can say, and also one defamation. Defamation victim is the rich. That's why he is filing the defamation. Ordinary person cannot file the defamation. Labor class cannot file the defamation suit. Only rich persons can file the defamation suit. So in fact,
में कौन है एससी शर्मा बेकार है
ये
कोई-
वर्मा साहब एक मिनट
सर।
आप म्यूट पे जाएंगे एक मिनट।
ओके सॉरी हाँ यस सर
so there must be some limit that after 1 year when he came to know about this statement, defamatory statement, action can be taken, but not unlimited. Before 10 years, your father said like this or you said like this. So indefinite period should be restricted to 1 year. And let us see what will be there. And this our Vikram Singh ji has told about the lynching, and there were several acts for the lynching earlier. For example, the Manipur Anti-Lynching Act 2019, Jharkhand 21, Rajasthan 19, and West Bengal 2019, where punishment was prescribed up to 3 years and fine was 5 to 25 lakhs. But now these all have been consolidated and will come here, and law will make simple by the IPC. And sentence is there. Just a moment. So with these points, I can say that this new law is a good law and will survive. And the discrepancies or anything else, the gap between the points, that will be filled by the judicial pronouncement in due course. Thank you.
Thank you for your important points you mentioned about it. And in this connection, Dr. Vikram Singh, there was an important point mentioned by Justice Satish Chandra about, these drug mafias, poisoning the entire societies. How do you feel that the new Samhita, Bharat Nyaya Samhita, will be able to take care of that?
Words of profound wisdom from Justice Satish Chandra, sir. And I would say that the new teeth that have been incorporated in the Bharati Nyaya Samhita, they will develop as force multipliers to the NDPS Act, Narcotics and Drugs Psychotropic Substances Act, because that also it has the harshest possible punishment, confiscation of property, right down to also. But what it does not have is the incorporation of the gang cases and also of detention as also enhanced punishment. So what was deficient in the NDPS Act has been incorporated in the Bharati Nyaya Samhita, and together I would feel that whatever works best in the cases of handling and defanging and neutralizing the drug mafia, I think that is the best solution. But I feel it is a situation where the nation will have zero tolerance towards the drug menace, the drug mafia, the crime syndicates, and also the support system that they enjoy vis-a-vis the bureaucracy and also the law enforcement agency. Because to strike a mafia you have to go much, much deep. Today, the situation is that we only act surface, meet surface. Only the petty drug peddlers are arrested. It is very seldom. Justice Satish Chandra sir has hit the nail on the head when he says, attack and strike at the mafia, at the kingpins, at the bosses, and not at the foot soldiers. And when that is the question, then you have to have an arsenal that is equal to the task. And I feel that the Bharat Nyaya Samhita is equal to this task. And together with application of mind, sound investigation, efficient prosecution, you will see the light at the end of the tunnel.
Thank you, sir. Thank you very much. It gives us a lot of hope that these challenges, like we are facing in Punjab and other states, would be taken care of. Would anybody like to ask any questions? Shri Devdutt ji, you would like to give your viewpoint?
Hello.
Yes, please. Please. I think you are on mute. Yeah. देवदत्त जी आप म्यूट पे हैं. हाँ, आप फिर से म्यूट पे चले गए. कुछ दोबारा. हाँ, अब ठीक है.
अब ठीक है
जी.
First of all, I would like to make commendable recommendations about the changes which have been made in this present system, and especially Dr. Bikram Singh and Mr. P.K. Malhotra, Justice Satish Chandra has already elaborated. For the last 8 generations, we are following the same IPC and same criminal justice administration system is there. And it is for the first time after 160 years that we have made certain changes which are need of the hour. And with the advancement of science and technology, the system of crime is also changed. If you see 1980, 2000 and 2020, there's a vast difference of crimes. And we have to take care of all those type of crimes which are taking place in the society. And reformation is a continuous system. So whatever changes have been made today, they may be needing some changes may be needed according to the time. So it is just an initiation which has been taken by government, and Parliament has passed these changes. I have heard Dr. Bikram Singh, who has made his recommendations in front of the committee, and I'm just praising him for making such recommendations, which he has excellent. He has an excellent record of police administration, right from SP to DG police, and still he is active and he is doing a lot of service to the society. And same, I would like to make commendations on Mr. P.K. Malhotra's wisdom, which he has suggested, and some changes are required in certain cases of crimes. Justice Satish Chandra has rightly said about drugs and other things. So which we think that now it is a high time to educate the administration, to educate our lawyers, to educate our judicial system, so that we can adopt these changes and make these things in a fruitful manner. This is all which I wanted to convey. Thank you very much.
Thank you, Devdutt ji, for your comments. Now, Maheshwari ji, आप कुछ बोलना चाहेंगे?
म्यूट पर हैं आप.
हैं? अच्छा, म्यूट पर. Thanks, Mr. Baklu, by giving this opportunity to say something before so big visionary and expert panelist of this for this subject. I am not a person concerned with this subject, but since it is the common person who knows this such type of changes which are affecting their lives, and definitely they must know, the people awareness must be there, so that they must know what the government, what the judiciary, what the police system, what the other enforcing agencies are doing with them, and what are their right to protect themselves, because security, safety, and protection is the main cause of every stakeholder of the country. So I think that before these panelists, I should not comment on this particular subject. And I'm thankful that I have listened, I heard to big views of the learned people. Thanks a lot.
By
Thank you.
Singh sir. Acha,
Uh,
now I would like to closing remarks from Dr. Vikram Singh.
Verma, you want to speak something?
Acha, okay, yes, Verma sahab, aap bataiye.
See, my point, we are very grateful to you, sir, for organizing such a wonderful webinar and inviting experts on this very contemporary topic. My one point of view is that today we live in a very dynamic society. We are seeing that there are a lot of new technologies coming in, and in the cyberspace, particularly the role of AI in policing and anti-policing is very much growing. So our laws, our systems should be such that they take care of these eventualities which are coming up and they deal with it. Yesterday we saw one animation where one politician fictitiously was talking as if he is the same person, like what was that was one very known very well Amir Khan, yes. So Amir Khan was being used to talk about propaganda, and when Amir Khan came to know, he immediately refuted it. So such kind of things don't happen. Public does not get different kind of signals. I think the law should be very contemporary and action should be very swift. So that was my point of view for the, otherwise it is an excellent, very well done. We need to continue these kind of webinars to make public aware as what are the new things coming up. Thank you very much.
Thank you,
And
Verma sir. Yeah, so thank you very much. Actually, this is an important point you have raised. Actually, we had limited time of 1 hour, but this part of fake news and maybe deep fake, etc., this issue is a serious issue. And I feel it has been partly addressed. I'm not an expert in this, under this Samhita also, I think. But of course, there are experts. We would like to have their comments also. So closing remarks from Dr. Vikram Singh. And in fact, we could also have another a webinar on the same subject where we'll discuss the other aspects of it. Thank you. Vikram Singh Saab.
Thank you so much, Mr. Baklu. Like any statute, any law grows, evolves, and blossoms with use. And then you come to know what is use, disuse, and misuse. It is only one application. The apprehensions in the police department, the investigators, the end users is absolutely discernible. But I feel that when you try any weapon, any technology, any law, these apprehensions are legitimate. But I'm sure in the course of time, they will all be addressed. And this is a wonderful statute, but only the acid test will come, faithful and impartial implementation of these wonderful rules. Thank you.
Thank you, sir.
Thank you very much for organizing wonderful seminar on
Thank
this
you, sir.
webinar. And
Uh,
secondly, in future, we hope that you will hold the same webinars on other topics and also CRPC, Procedure Code and Evidence Act.
Yeah,
also.
certainly we'll do
So
that.
that will continue. And thank you very much for having the serious, very serious topic for discussion. But
Thank
on
you, sir.
lighter side, there are the 4 laws, and 3 must go away as per today's WhatsApp. That is, the father-in-law, mother-in-law, and brother-in-law must go, and only one should be retained. That is the
Yeah. Thank you, sir. Thank
very
you
much.
for
Thank you, sir. Thank you,
to
sir.
this serious discussion. Thank you very much. And now closing remarks from Malhotra sir.
I think the changes made in the Indian Penal Code with the new legislation passed by the Parliament were long awaited, and probably government has taken a bold step by updating the criminal justice administration by bringing a new principal legislation to deal with the crimes, and the obsolete laws which were there in the IPC have been deleted and new crimes have been added. And I'm sure that the justice delivery system for the common man will become more effective with the introduction of this new legislation. And I wish all the success to this legislation.
Thank you, Malhotra sir. Now, with this, we come towards the end of this webinar. I would like to thank the panelists, Dr. Vikram Singh, Shri P.K. Malhotra, for their participation and in the process adding value to this webinar. I would also like to thank Justice Satish Chandra, Shri Devdutt ji, and Mr. Maheshwari for their, and also Mr. Verma for their points, important points. So I would now request Shri Maheshwari for his, vote of thanks.
Thank you, Bakul sir. And we are also thankful to the eminent personalities of this discussion. And we hope that this discussion will continue, because the awareness of this law must go to the general public, and they must be aware what has been done and what are now their rights. And we also request you to kindly continue this. And we are also thankful to the Justice Dr. Satish Chandra ji, Dr. Vikram Singh ji, Sri P.K. Malhotra ji, Sri Devdutt ji, Dr. Verma ji to join this and put their valuable comments and valuable opinions to aware the public. Thank you all. Thanks a lot.
Thank you. Thank you. We'll meet again next month with the new topic. Thank you very much.
Sure, sir. Thank you, sir. Thank you.
Thank you.
Bakul sir.
Thanks a lot for everyone, sir. This was a wonderful webinar. Thank you, sir.
Thank you, sir.
Thank you,
very
sir.
much.
Thank you.